They thought my lake was just another neighborhood perk, a scenic bonus tucked behind a few homes. Some pretty backyard water feature the HOA could slap on their brochures and claim as a shared amenity. At first, it was subtle, a few comments at meetings, casual mentions of community use. Then came the flyers. Annual Hill Ridge Barbecue by the lake. My lake. No permission. No conversación. Then came the signs. Lake Hill Ridge, for resident use only. Posted on my fence. I walked out one morning, coffee in hand, and stared at the laminate sheet stapled into my property post, like my backyard had been redistricted overnight. No heads up, no explanation, just entitlement. And it got worse. They filed a permit to build a dock, sent out party invites. Karen, the board president with a clipboard for a crown, told residents to bring a dish and a towel. That was when I called my attorney. What they didn't realize, this wasn't a community pond. This wasn't common ground. This was titled land, legacy land, paid in full, registered in my name. And when my attorneys started digging, we found forged maps, fake easements, and an illegal land grab dressed as a potluck. They thought it was a lake. They were about to learn. It was a line, and they just crossed it that if an HOA can steal a private lake by altering paperwork and pushing fake easements, how many other homeowners are vulnerable? What starts as a flyer about community use turns into fines, threats, and construction permits, all aimed at land you paid for, you maintain, and you hold a title to. That's what almost happened to me. They tried to turn my private lake into a public venue, without consent, without jurisdiction, and without facing a single question from the residents they claim to represent. If I hadn't fought back when I did, they'd be hosting parties on land I pay taxes for, while fining me for saying no. And if I had let it slide, even once, I'd be opening the floodgates for every clipboard-wielding neighbor with a thirst for control. Because once you let that happen, once you allow someone to redraw the lines you inherited with ink and arrogance, you never get your rights back. This wasn't about a lake. It was about ownership, boundaries, legacy, and if they wanted a courtroom fight to find that out, I was more than ready to give it to them. Some people inherit jewelry. Others inherit land. I inherited water. 3 acres of deep, calm lake tucked behind the tree line, hidden like a secret between the pines. My grandfather bought it when land was cheap and fences were handshake lines. He built the dock by hand, dug a fire pit on the bank, planted a ring of maples around the far edge that turned blood red every fall. For 40 years, that lake was his pride. Then it became mine. After he passed, the deed transferred to me. Full title, clean history, clear boundary markers. It was never part of the neighborhood that crept up nearby. Never listed in any community asset registry. No shared agreement. No easement. Just me, the water, and a paper trail that proved it. For years, nobody bothered me. The lake was quiet. Still, private. And then the HOA expanded. At first, it was just chatter at the edge of the development. New homes, landscape walkways, a community newsletter full of block party photos and friendly reminders about lawn length. Nothing to worry about. Until one morning, I received an envelope in my mailbox. It was addressed to all residents of Hill Ridge Grove. I almost tossed it. I wasn't in Hill Ridge Grove, but I opened it anyway. Inside was a flyer. Annual Hill Ridge Community Cookout. Saturday, 3 p.m., Lakeside Pavilion. Games, food, drinks, and fun by beautiful Lake Hill Ridge. Lake Hill Ridge. I read it twice. There's only one lake within a mile of the subdivision. Mine. At first, I thought it was a mistake. Some mix-up in naming or venue. Then I drove down the access trail to check. That's when I saw the sign, tacked onto the edge of my wooden fence, just above the old metal, private property, no trespassing plaque. Lake Hill Ridge, for resident use only. Please keep the area clean and respect nature. HOA board. The audacity didn't even hit me right away. It took a second for my brain to register what I was seeing, a laminated, branded sign telling people they could enjoy my land. Like I was just a landscaper. I called the HOA office. Got a voicemail. Tried again an hour later. Finally, someone answered. Young voice, polite but evasive. I asked who authorized the sign. There was a pause, then a cheerful, "That would be Karen." Our board president. Karen. Of course it was. I'd met her once, briefly, at a local zoning meeting 2 years back. She wore a sun hat the size of a trash can lid and introduced herself with a tone that implied she'd already read your credit score. She gave me her card and said, "If you ever want to add benches or signage near a water line, let us know. We love partnering with nearby property owners." I never followed up. Apparently, she did. The next day, I got another flyer. This one was hand-delivered, tucked into the crack of my door. Same party, same time, but now it had my lake's GPS coordinates printed on it. I didn't even know where to begin. I pulled the deed from my safe, printed it again, just to be sure. Full title, dated back to 1968. Lot 13A. Includes lake and 10-foot perimeter. No easement. No shared access. No mention of Hill Ridge anywhere. I took photos of the signs. Drove to the HOA office. This time I went inside. Karen sat behind a desk, flipping through landscaping proposals. When she saw me, she smiled like we were old friends. "Well, hello. You must be here about the cookout." I placed the flyer and the deed on her desk. "No," I said. "I'm here to ask why you're scheduling events on my property without permission." Her smile didn't falter. It just tightened. "Oh, there must be a misunderstanding," she said smoothly. "That lake's always been a shared feature for the community. We've hosted nature walks there for years." "Hosted them where?" I asked. She waved vaguely. "On the west side. That little gravel path is practically an easement." "It's not," I replied. "It's a deer trail, and the entire lake is privately owned. Always has been." She leaned back, folded her arms. "Well, that's debatable. Our maps show the shoreline as community-accessible green space. Maybe your records are outdated." That's when I knew. This wasn't ignorance. This was a play. "Cancel the party," I said. "Take down the signs. Or I'll call the sheriff." She didn't flinch. "Oh, we've already invited over 40 families. Rescheduling would be disruptive." I left before I said something that would end up in a deposition. But as I walked out, I passed the community bulletin board. On it was a new flyer. "Lake Day is happening rain or shine." That was the moment I stopped being polite. Because they weren't just trespassing. They were rewriting the story, turning my family's legacy into a rental venue, one potluck at a time. And if they wanted to test where my line was, they just found it. Right at the water's edge. I thought that was the end of it. After the confrontation with Karen, I expected some retreat. A quiet cancellation. Maybe an email pretending it was all a mix-up. I even half expected her to claim she never saw my deed. Instead, I got a knock at my door from a county clerk, delivering a formal notice of proposed construction. The paperwork was slick, polished, looked official. The description? Small-scale recreational pavilion and floating dock structure to serve community members. Proposed location, south bank of Lake Hill Ridge. Lake Hill Ridge. There was again, that name they made up and kept repeating like it would eventually become real. But the part that stopped me cold was the parcel number listed on the form. My lot, my deed, my lake. The permit was filed under my land, as if it was theirs. I went straight to the county recorder's office. Marcia, an old friend of my grandfather's, looked it up with a furrowed brow. "This is strange," she said, scrolling. "Our primary records show the lake's yours. But this," she pointed to a newer, digital scan of a map filed 6 months ago. There, in soft gray overlay, was a faint line stretching from the edge of the HOA development, right through my property. A label hovered above it. "Proposed shared access, historical pathway easement, pending finalization." I stared at it. Historical what? She zoomed in. No supporting documents on file. But it looks like someone submitted it along with a batch of zoning updates. I asked for a copy. She gave me a printed sheet, stamped and time-marked. The name of the submitting party? Stephen Klein, HOA board member. Karen's right-hand man. Back at home, I logged into the HOA's public meeting archive. Every agenda, every note, every vote since the community formed. Took me 2 hours to find it. Buried in the April meeting minutes. Motion to approve updated green space and trail alignment. Map revision includes access path for community lake events. Seconded. Approved. No one questioned it, because they never said my name. Never mentioned the parcel number. They just slid it in like a shell under the cup in a street game. The next letter came the following Monday. It was a fine, issued by the HOA. Violation: interference with approved recreational area. Fine: $1,250. Description: resident, redacted, confronted community members and board leadership regarding sanctioned use of Lake Hillridge without board approval. Violation of Community Harmony Clause and Event Disruption Policy. I laughed out loud reading it. Then I read it again and didn't laugh. Because that fine? That's what made it official. That's when this stopped being a misunderstanding. They were building a paper trail, a narrative. The angry lake guy, the one disrupting community events, the one who didn't want to share. Then came the community backlash. It started on the neighborhood forum, a few passive-aggressive posts. I guess some people think their view is more important than the rest of us having fun. Shouldn't natural features be enjoyed by everyone? It's literally just sitting there. We've been walking around that lake for years. Suddenly someone says we're trespassing. Some of the residents back me up. Older folks who remembered when the HOA was first built, who knew that the lake was always private. But others? They didn't care about deeds. They cared about access, free parties, convenience. They saw the lake, assumed it was theirs, and once Karen gave them permission, they never questioned it. That night, I stood on the dock my grandfather built and looked across the water. Reflected in the still surface were the trees, the stars, and the future they were trying to rewrite. If I didn't act now, this lake wouldn't just be stolen. It would be rebranded, repackaged, reclaimed. The pavilion permit would pass. The dock would go in. Families would throw parties here and call it theirs. And within 5 years, some kid would grow up believing the lake was always part of the HOA. And when I complained, they'd call me bitter, or worse, irrelevant. I walked back to the house, opened my drawer, pulled out my grandfather's file, the one with the original land grant and tax logs dating back to the 70s. Then I picked up the phone and called my attorney. My attorney's name is Benahale. Soft-spoken, tailored suits, smiles like he's heard your argument already and has 6 court precedents to dismantle it. When I walked into his office and handed him the flyers, the fine notice, and the permit proposal, he didn't blink. He just flipped through the documents with the calm curiosity of someone reading the first page of a book he already knew the ending to. "Did they sign anything?" he asked. "No, nothing. They just started acting like they owned it." He nodded, then picked up the stamp parcel map Marcia at the county office gave me. "This line here," he said, tracing a finger over the altered easement, "doesn't exist in any legal filing. That's a fictional border. They're trying to create jurisdiction through perception. And the fine?" He smiled wider. "Now that's a gift. They just made themselves liable." The first letter went out the next morning. Cease and desist. Addressed to Hillridge Grove HOA and its acting board president, Karen Miller. Any and all activity related to planning, promoting, or accessing Parcel 13A for recreational or communal use must stop immediately. Continued misrepresentation of ownership, land designation, or access rights constitutes willful trespass, abuse of process, and fraud. I asked if I should expect a reply. Bennett shook his head. "They'll stall, or try to scare you back." The second strike came with paperwork, thick and undeniable. Bennett submitted a formal land survey, notarized and marked with GPS verification, showing that Parcel 13A, the lake and its banks, had never, not once, been designated as public, shared, or HOA managed. Along with it went 3 decades of tax records, receipts, assessments, and filings that clearly listed me and my family before me as the only people responsible for that land. No shared fees, no cross-property easement, just black and white truth, filed with the county clerk and city zoning commission. But Bennett wasn't done. He filed for a temporary restraining order against the HOA, barring them from hosting events on the lake, advertising use of the lake in newsletters, filing additional permits, accessing or modifying the shoreline in any way. This wasn't just defense anymore. It was a legal quarantine. And the minute the injunction went live, the HOA's tone changed. Karen stopped smiling. Within a week, Bennett received a panicked email from the HOA's legal counsel. a small-time firm that clearly didn't expect their community bake sale club to get hit with a multi-page affidavit and a formal injunction. Surely this is a misunderstanding. We believe the lake had implied communal access, per historical precedent and community integration. That's lawyer speak for. We thought we could get away with it. Bennett responded with one paragraph. Your client knowingly acted beyond their jurisdiction. Your misinterpretation of historical precedent is not a substitute for legal ownership. Then he added an attachment. Karen's own emails. Because while Bennett filed court papers, I'd been digging too. Karen had a nasty habit of copying half the world on her correspondence. And thanks to one sympathetic HOA board member who never agreed with her tactics, I got access to a batch of internal communications. One email stood out. If we reclassify the trail on the west side as a green access point, we could link it to the lake on the new zoning maps. It's not a formal easement, but if we use the language correctly, we can treat it like one and apply pressure. Apply pressure. That's the part that did it. Not partner, not request, not inquire. Pressure. Karen never planned to negotiate. She planned to coerce. Bennett filed the emails as evidence, alongside the flyers, signs, and the fraudulent fine notice. We scheduled the court hearing, and while the HOA scrambled to save face, I walked my property line and started gathering witnesses. Neighbors, mostly older ones. Folks who'd been here long before the HOA expanded. People who remembered when my grandfather cleared brush along the lakeside and planted saplings just to keep the deer from eroding the bank. Mrs. O'Donnell down the road? She had photos, black and white prints from the 1980s, showing my grandfather fishing alone on the dock, a hand-painted private property sign nailed to a post in the background. Another neighbor, Mr. Rayner, gave me a notarized statement. To my knowledge, this lake has always been owned by the redacted family. It was never part of the neighborhood or its planning maps. Any claim otherwise is false. I included 5 witness statements in our prep packet. By the time we finished assembling the file, it was a book. Karen tried to fight back. She sent out a community-wide email, subject line, "Protecting community spaces for all." In it, she claimed I was retracting access to a space that had always been part of the community's culture, and that I was choosing selfish litigation over neighborly compromise. People started whispering again, but this time, they also started wondering, if he's so wrong, why does he have a lawyer? Why did the court file a restraining order in his favor? Why does he have paperwork and Karen has flyers? Doubt. It creeps in like water under a cracked dock. Karen's grip was slipping, and she knew it. On the eve of the court date, Bennett called me. "You ready for tomorrow?" I nodded. I've never been more ready to tell a judge I own a lake. He laughed once. Let's make sure they never forget it. The courtroom was smaller than I imagined. No sweeping mahogany-pidos. No gavel-cracking drama. Just a few rows of wooden benches, a county seal above the judge's bench, and a low murmur of people who thought they were showing up for a zoning dispute. But to me, it was a battlefield, because this wasn't about a fence line or a boundary scuffle. This was about ownership, and the people who thought they could erase it with a flyer. Karen sat with 2 HOA board members and their attorney, a young guy with a briefcase too new and a suit too tight. He kept whispering and adjusting his tie like he knew what was coming, but had no way to stop it. I walked in with Bennett Hale beside me, confident, calm, holding a stack of files so thick it looked like it had weight of its own gravity. The judge entered, a woman with silver hair, sharp glasses, and a voice that didn't tolerate rambling. We all rose. She gave one look at the docket and said, "Let's begin." The HOA's attorney opened first. "Your Honor," he said, "this case is not a question of ownership, but of community access. For years, residents have enjoyed passive use of what is colloquially known as Lake Hill Ridge. Our client merely attempted to formalize that usage for the benefit of the neighborhood. He used every soft word he could find: integration, shared space, community spirit." He gestured toward Karen, who sat with hands folded like a queen in exile. Then he added, "The proposed events were non-commercial, open to residents, and reflected the community's long-standing relationship with the lake." Bennett stood. "No preambid, just precision." "Your Honor, what the defendant just described was not a misunderstanding. It was an orchestrated effort to seize land that does not, and never has, belonged to them. He handed the judge a file. Inside, the deed, the survey, the tax records, the restraining order, and most damning of all, the HOA emails. He opened with the April meeting minutes, where the HOA quietly voted on easement language without ever notifying the property owner. Then he moved to the sign installation, laminated placards declaring public access, posted on private fencing. Then the fine. They fined my client, Your Honor, for objecting to a barbecue being hosted on the land he inherited. Land he's paid taxes on for over 2 decades. Land not included in any subdivision plan, not listed in any community agreement, and never once offered for public use. The judge flipped through the documents slowly, eyes narrowing. Then Bennett reached the final nail. Karen's email. If we reclassify the trail on the west side as a green access point, we could link it to the lake on the new zoning maps. It's not a formal easement, but if we use the language correctly, we can treat it like one and apply pressure. He let that sentence hang in the air. The courtroom was silent, heavy. Then the judge turned to Karen. Did you write this email? Karen shifted in her seat. I was exploring options. We thought it might. Answer the question. Yes, she said, voice small. The judge set the file down, removed her glasses, then leaned forward. I've seen land disputes before. I've seen honest confusion, survey overlaps, even shared access paths mistakenly maintained for years. But what I see here is different. This isn't confusion. This is deliberate misrepresentation. Your board knowingly submitted altered maps. You posted signage on land you do not own. You find a rightful owner for defending his legal property. And then you try to justify it with a false narrative of community benefit. This court will not entertain fantasies built on fraudulent filings. Karen's face drained of color. Her attorney tried to recover. But Your Honor, the residents. The judge held up a hand. I've heard enough. She turned to the clerk. Strike the pending permit from county records. Issue an order for removal of all signage within 72 hours. Assess court costs and attorney fees to the HOA. Further, notify the County Zoning Commission of the misrepresentation and place the HOA under compliance review for misuse of municipal resources. Then she looked directly at Karen. As board president, you bear responsibility. I recommend your immediate resignation. Consider yourself reprimanded. Whispers spread through the courtroom like wind over water. Soft chuckles. A quiet finally from someone in the back. Karen didn't look at me as she left. Didn't say a word. She walked out quickly, followed by her lawyer, trying to whisper damage control before the doors closed. Bennett packed up the files like he had never doubted the outcome. Nice work, I said. He smiled. No, that was your grandfather's work. I just read the map. The signs went up quietly, just before sunrise. Simple black text on white aluminum. Private lake. No trespassing. Protected by court order. Docket hashtag C. 12497PL. I installed them myself. One at the old trailhead. One at the far dock. A third where Karen once stapled her community flyers to my fence post. This time, no one tore them down. No one dared. The county followed through. The permit was struck from record. The maps were corrected. The altered easement lines? Deleted. A zoning officer even called to apologize, said the new boundary clarifications were now publicly indexed with my name as the legal owner, sealed, and immutable. We won't let this happen again, she told me. I believed her. Karen resigned. Not just from the board, from the neighborhood. Her house went up for sale before the ink was dry on the ruling. No open house. No moving truck. Just one day gone. The listing read, charming colonial near a beautiful lake. But no one mentioned she tried to steal it. The HOA scrambled to save face. Special elections were held. New members voted in. This time, people paid attention to who got the clipboard. And me? I started something new. Something older than courts and signs. A conservation fund. Named after my father, who inherited the lake from his father, who never asked the world for permission to love something quietly. The fund sponsors shoreline cleanups, restores the maple ring, hires local students to study turtle migration and fish health in the summers. A retired ranger helped me set up a wildlife camera near the North Bank. People still ask if they can visit, but now they ask. They knock. They bring their kids, walk the line respectfully, and leave without trash or assumptions. No more flyers. No more signs claiming ownership that isn't theirs. Just shared reverence from the other side of the fence. One evening, just before fall, a couple came to the gate with their daughter. She pointed at the lake and whispered, "That's the Story Lake, right?" I asked what she meant. The mom smiled. The one in the news, where the man didn't let the people take it, and the judge made it safe again. I nodded. "Yeah," I said. "That one." The girl waved at the water like it could wave back. It didn't, but the wind picked up just a little, and the ripples moved gently toward the dock, like approval. The lake's peaceful again, not just in reflection, but in law. The lines are clear now. The legacy is real, and the people who tried to rewrite it, they're gone. Truth floats. Always. And this lake, it's still mine, still private, still full of memories you can't fabricate with signage or permits. Now it's protected, not just by fences and filings, but by the people who know what it means to keep something sacred. And if anyone ever forgets, I've got the ruling framed in the boathouse, just in case they thought my lake was a community feature, a decorative backdrop for their parties and picnics, a quiet corner of nature they could slap a name on and call shared. But property isn't about appearances. It's about truth. Lines drawn not with chalk, but with deeds and decades of care. With taxes paid, with fences maintained, with fathers and grandfathers who didn't need a sign to know what they owned and what they were protecting. When you let power rewrite boundaries, you don't just lose land. You lose legacy. Because if one flyer, one vote, or one clipboard can erase your rights, then what you've built, what you've inherited, was never yours to begin with. And that's not how legacy works. The next time someone tells you what's theirs, ask to see the deed. And the next time they point at something beautiful and claim it as for all, remember this. Silence may keep a lake still, but the law protects its shores. And some waters run deeper than any permit they'll ever forge.